The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. This afternoon, we have 2 cases that are set for oral argument and 2 additional cases that will be submitted without oral argument. First 2 cases are Thomas Lukken versus Fleischer et al. Second case is Koster versus Harvest Bible Chapel. Third case without oral argument is Bauer versus Brinkman. And the final case without oral argument is Tony versus Parker and others. So we'll start with the Lukken case, and let's do a quick time check. I'm going to ask either Mr. Henderson or Mr. Weiner, whoever's going first, to do a sound check. We've got Justice Apple participating remotely.
Check, check.
Thank you. I can hear you. Thank you very much, Counsel.
And Mr. Lathrop, if you do the same, and then once we're sure it's working, you can begin your argument.
Good afternoon.
Thank you very much, Counsel.
You may begin. Thank you.
Thank you. May it please the court, my name is Matt Lathrop. I represent the appellant here. Before the court are 2 issues to decide. First, will this, is summary of judgment appropriate in a case with evidence of willful inaction and gross negligence, creating a genuine issue of fact in this case? And the second issue before this case is, will this court choose to enforce a waiver of liability in a case of gross negligence and willful inaction using Iowa's current case law, which up to this point strictly limits application and enforcement of these waivers to the clear language of the release? There is evidence before the court in the record of gross negligence and willful inaction, and on the part of both defendants in this case, both primary defendants, which are Challenge Quest, which I may refer to as CQ, and Mount Crescent. Challenge Quest, who built, designed, put into operation, inspected, and put into service the zip line in Mount Crescent, ignored industry safety standards in its design, its construction, and then the construction and design delivered helpless riders to a landing area with no fail-safe protection from collisions with people or the platform. The design did not meet industry standards. The evidence is clear. It did not, that is, Challenge Quest did not provide an owner's manual or the necessary safety training to establish and ensure the continued safe operation and ongoing safe operation of the Mount Crescent zip line, and then twice passed the zip line in later inspections as meeting ACCT safety standards when clearly it did not, because at a minimum it lacked the emergency brake, which we're here to talk about.
Does any of that matter when the braking system was replaced with that provided by another manufacturer?
Thank you for the question, Justice Waterman. I think the discussion of the replacement of the brake is a red herring for 2 reasons. First, it was not the replacement brake that failed. It was the employees' inattention and failure to deploy the brake. Either braking system would have resulted in this outcome. There's nothing about the replacement brake that was involved in the injury other than it wasn't deployed, which was human error. So that's number one.
Counsel, if I could
Yes.
follow up on that point. So it's my understanding, and correct me if I'm wrong, that the first sort of braking system involved an employee kind of holding onto a rope that slid as the participant came down the line to the end, and the replacement brake was different in that it required the employee to take some action to sort of load the brake so it could be in place to actually stop the participant.
The testimony from both Mount Crescent and CQ is that each brake, regardless of how they came into the landing area, required manual operation to get them redeployed. The rope one required tethering the rope out by hand. The zip line was an automatic thing. A clip was released after the rider was disengaged, and the brake was deployed.
Why aren't you pursuing the company that supplied the replacement brake system?
Because the problem was not the replacement brake. The active passenger brake, which we're discussing right now, was not deployed. It did not operate incorrectly. The ACCT standards say there have to be two brakes, and I have to use the analogy of an automobile. An automobile is a machine that has an active brake that we all use when we're driving, and it has an emergency brake, which is a separate component and completely different. And the problem in this case was that there was never an emergency brake in the design or the construction or the inspection approval that was the entire purpose of which, under the ACCT standards, the safety standards say there has to be a secondary passive brake that works no matter what, because we are going to have operator error when we do these things.
I thought there was some evidence that the standard for that brake applied only in certain circumstances where the rider was approaching the platform at a particular speed, something along those lines, and that under the system as installed by CQ, that it wasn't necessary. Is that incorrect?
A lot of what you said is exactly correct. There has to be a secondary brake. If you arrive at the platform at a speed greater than 6 miles an hour, there has to be a secondary brake. Cody Goodwin, the designer and builder of the zip line, said, my brake that I designed and installed did not require a backup brake because it's all one component. If I'm using the rope and I'm holding the rider when he comes in, there's no need for a backup. Mr. Goodwin was asked about that specific thing in the deposition. I asked him, if that brake that you installed, the rope brake, the grip brake, is not deployed, does the emergency brake work? And he said, if the brake's not out, the brakes don't work. So, and it's clear from Eric Martyr's expert report that passengers arrive at that landing area in excess of 35 miles an hour if they aren't braked by that primary active passenger brake. There's nothing to stop them if that brake isn't out from slamming into a telephone pole at the end of the line. And that's why the primary brake is not the question here. The question is, there was never an emergency brake. And by the way, Cody Goodwin, when he installed the rope brake, did not do it with the consent of the engineer who drafted the plan. The engineer who drafted the plan called for ultimately what was installed later. Cody Goodwin did it under his own decision and without an engineer's approval.
Counsel?
Yes, I'm sorry.
So when Skyline installed the new brake system, did they have an obligation to put in an emergency brake at that point?
This is a great question also. The only evidence we have of Skyline's any involvement here is an invoice or an estimate for services. And what we know from the evidence that is in the case is that Mount Crescent purchased the active passenger brake. There is nothing in any of the evidence that gives us a scope of agreement or any ability to infer a duty on the part of the Canadian group, Skyline, for anything other than installing the brake and inspecting the brake they installed to make sure it was done correctly. And we have a lot of contract law floating around in this case, and there is no contract, there's no service agreement that shows what Skyline was supposed to do. Thank you.
Counsel.
I'm sorry, yes.
Yeah, I'll take you to a different point.
All right.
On the contractual waiver, is it your argument that the waiver itself, the release itself, wasn't clear enough as to whether it was releasing gross, or is it that gross negligence can never be released at all?
Your Honor, or Justice McDermott, thank you for the question. My first argument is that gross negligence as a public policy should not ever be allowed or enforced by this court because of the public policy. This is, there's case law from this court that says we will only look at, or the court's analysis is of the activity involved and whether there's a public interest in that activity. And it's appellant's position that the court can and should also look at the outcome of that activity. And with the Mount Crescent zip line, the outcome of this grossly negligently designed, built, and run operation is not the possibility of injury, but the it's even more than probability. We are having injuries occur, more than one. Mr. Lukken was not the first, and injuries were occurring before and after. Mr. Lukken's is just the most serious, and there are no documentation from Challenge Quest or from Mount Crescent about these injuries. So that's number one, is that when we are talking about gross negligence and the testimony of the parties themselves, the defendants themselves, that if we don't follow standards, people will be injured and killed. That's what gross negligence in cases like this result in. So that's number one. Number two, your question about the policy language or the waiver language itself. It is appellant's position that this court has always held the drafter of these waivers to the strict enforcement of the language in the waiver. And this waiver does not include gross negligence. And there's ample case law in this state that reflects that gross negligence has its own standard of proof, its own prima facie case, and its own elements. And we argue that this court would not want to blur the lines between ordinary negligence and gross negligence with a case like this. Thank you for the question.
Would we undermine the usefulness of these waivers by allowing somebody to plead around them just by alleging gross negligence? I mean, is that going to impact school field trips and a variety of other activities we want to encourage through the use of liability waivers?
Justice Waterman, my answer is this, that we have a case where a provider, the All-Store case, where they drafted a release or a waiver, and in the All-Store case, they said gross negligence is included, and without getting into whether that was gross negligence, the court enforced that waiver. So the language, we know how to draft valid waivers, including gross negligence. The policy question becomes for this court, do we want to enforce waivers that allow gross negligence? Because the problem here, as this quote from Mr. Fleischer indicates, is that I asked him, what has changed since we learned about what happened to Mr. Lukken and you learned why this failure occurred? And his answer was, well, it's human error. I mean, what's changed at Mount Crescent? I'd say nothing's changed. And I would suggest that nothing will change at Mount Crescent as long as waivers are still enforced against gross negligence. So here I think the more solid ground I stand on is that the waiver just doesn't include language of gross negligence. And we know from the All-Store case how to draft waivers including gross negligence.
In making that distinction, or kind of the public policy question on gross negligence, should we take into consideration the kind of activity involved and make distinctions between, you know, purely recreational activities or maybe inherently dangerous activities versus, to use Justice Waterman's example, school field trips?
I think that the distinction is always the devil in the details, but my answer would be that when there is gross negligence, the question becomes, is there a probability of harm? And what is the probability of harm? That's what our gross negligence case law says. In a field trip, is it likely that someone is going to be exposed to injury, catastrophic injury or death? Well, we know from the Sweeney case that a young girl went to a baseball game in Bettendorf and was injured by a flying bat, but that's also an understood risk of going to the game. And I think the court discussed that right and went to the fact that the Sweeney case was not about the ordinary risks of going to a baseball game, but it focused, or the part of the decision focused on the fact that this is about supervision, and I would argue it can be extended to training and the operation. So the long way around the barn, and I apologize, is that I just think that when we are talking about gross negligence involving a high probability of injury, the public policy is to protect our people and not allow businesses to not only run a dangerous operation, but have no incentive to make it any better.
Counsel, the waiver refers to any and all acts of negligence. What am I to make of the words any and all? Does that have any heft? Does that do any work in this case that would separate it from, say, gross?
It's such an easy answer for me to provide you, Justice McDermott, and it is this. We have the Lathrop versus Mount Crescent case. My sister-in-law is going down the hill on an inner tube and injures her back. A bad injury, that's ordinary negligence, if any negligence at all. Any and all negligence can come from going down the ski slopes, hitting a tree, hitting a stump, riding an inner tube, falling on the stairs because it's snowy or icy. This is a different animal. Gross negligence has its own body of law and its own definitions, and it is not ordinary negligence. Ordinary negligence in this case is forgetting to throw the brake out. Gross negligence is designing, constructing, and operating a system with no more knowledge about how to do it than anybody in this room has. And what happened when CQ turned that zip line over to the owners of Mount Crescent said to any one of us, create your own safety manual, your own owner's manual, and good luck. And that is why this is gross negligence, and that is why the injuries and the harm will keep piling up until we ask these businesses to at least meet some level of ordinary negligence. So any and all, there's a lot of different types of ordinary negligence. But when we talk about gross negligence, again, Allstor told us how to draft that release.
I'll let you wrap up your first argument
Okay.
before you have a chance for rebuttal.
With that, I'll just sit down and see what I need to talk about after and listen. Thank you.
Thank you. It's my understanding that Mr. Weiner will go first. Thank you. And by the way, we keep track of the total time, but we leave it up to you guys to figure out how you're going to break it up.
Good afternoon, and may it please the court. Josh Weiner, and with me is my colleague today, Robert Slavic, appearing on behalf of the defendant, Appellee Challenge Quest, LLC. Plaintiffs failed to connect any act or omission on the part of Challenge Quest to the ultimate cause of plaintiff's injuries in this case, admitted human error. And but for that human error, we wouldn't be here today. There's three fundamental and undisputed facts that demonstrate why summary judgment in favor of Challenge Quest was proper.
Well, wait a minute. Challenge Quest designed the original system, right?
That's correct.
And then the way it's characterized by the other side is the braking was replaced, but the original design was still flawed because there was no backup braking. If that's the case, why don't they get to have a trial against your client?
That's a perfectly great question, Your Honor. And I'll start by saying whether the original braking system installed by my client had an emergency brake is not a disputed issue of material fact. And the reason's simple. Because the moment Mount Crescent hired a new company, Skyline, to install an entirely new braking system called Zip Stop, the original braking system becomes moot. And if the new braking system that was installed required an emergency brake under the ACC standards, it was the duty of Skyline, the third-party company that Mount Crescent hired, to ensure that this new braking system met those requirements. And as the district court properly found, that's a superseding intervening cause that shields Challenge Quest from liability.
Counsel, does the record explain whether or not a different emergency system would have been installed when Skyline installed their system? Or in other words, if QC would have designed it originally with an emergency system, braking system, and then Skyline came in and put in their system, would that have affected the emergency system? Are those two, your co-counsel or your opposing counsel wants to say that those are two very different things, and what's your response to that?
Well, you've raised a few separate issues, and I'll try to address all of them. First of all, when Mount Crescent hired Skyline to come out and install a new braking system, it became the duty of Skyline to determine whether or not an emergency brake was required under its system. Now, I would submit that the evidence submitted in the record doesn't reflect that the Skyline system needed an emergency brake in the first place. But we'll accept that true for purposes of summary judgment motion.
So can I interrupt you for just 1 second?
Yes.
So is that a fact issue about whether or not an emergency brake is always needed or not needed with
It's
certain
not.
systems?
It's not, Your Honor, and the reason's pretty simple. You know, we've accepted for purposes of summary judgment that if our braking system under the original braking system needed an emergency brake, that liability was cut off the minute that Mount Crescent hired Skyline to bring in their own braking system through the zip stop system. And Mount Crescent's 30B6 representative stated that he expected Skyline to follow ACC standards and to determine whether or not their system needed an emergency brake. But I want to get back to the ultimate cause of...
Can I follow up on that? Isn't it possible that both CQ and Skyline could have been negligent or grossly negligent in not having an emergency brake? And as I understand, the plaintiff's argument is that there's two kind of separate braking systems. You have a kind of a primary brake and then this second emergency brake. So if Skyline was contracted only to, let's say, fix or replace the primary brake, isn't it possible that the non-existence of an emergency brake could still be a cause of harm or negligence on both parts?
Well, a couple of points to that, Your Honor. And first, I'd say that whether or not the emergency brake was required under the zip stop system has no relation to whether or not the emergency brake was required under our system. Because if it was required, basically the argument that the plaintiff has raised is, well, if the braking system that we installed was defective, then it must have been foreseeable that a third-party company would come in and also be negligent in failing to install their own emergency braking system under the new braking system. I do want to get back to a point that Justice McDermott raised, which is the differences between the original braking system and the zip stop system, because it is, I think, an important point. And under the original braking system, it required an operator to apply force to a rope. The zip stop system, it's an automated braking system. It uses magnets to apply force to bring the rider to a stop. But importantly, the zip stop system, it automatically deploys once the rider comes in. And because of that, the testimony from Mount Crescent's representative is that they used a carabiner to put the zip stop system in place so that, you know, as the riders are leaving the platform, it won't redeploy. And once the next rider is ready to come down, they'd release the carabiner and it'd go out. And that's what the operator forgot to do in this case. But ultimately, I want to get to the human error that's an issue in this case. If all we're left with is the admitted cause of the accident, human error, it was the duty of Skyline to, in failing to reset the brake block. Challenge Quest is not a legal or approximate cause of plaintiff's injury in this case.
What about there's some suggestion about training and a safety manual and so forth. And the implication, I gather, is that if there had been a safety manual and appropriate training, there would have been more awareness of A, the need for a second emergency brake, and B, what to do in the event of these kind of situations. What's your response there?
You provided me a great segue to my next point, Justice Appel, so I appreciate that. So plaintiffs argued that Challenge Quest failed to provide adequate training and documentation to Mount Crescent. But again, there's no causation, and because there's no causation, there's no issue of material fact. And the reasons for this are simple. First, once the zip stop system came into place, the documentation and the training that Challenge Quest did provide on the original braking system became immaterial. And if additional training or documentation was required once the zip stop system was in place, then that duty lies at the feet of Mount Crescent or Skyline. There's no dispute in this case that Challenge Quest provided 4-day on-site training to Mount Crescent's employees in 2014, and then it turned over the zip line. And that was all that was required of Challenge Quest under the services agreement between it and Mount Crescent. But Challenge Quest wasn't hired to prepare Mount Crescent to do its own training. It wasn't hired, and it was specifically warned that training needed to be done annually and by qualified people. And essentially what plaintiffs imposing upon Challenge Quest is a duty in perpetuity to make sure that Mount Crescent is following safety standards, safety protocols under new braking systems that we have no idea about. That's just not a duty that's feasible as a matter of public policy. Now, plaintiff, as Justice Apple pointed out, has argued that Challenge Quest failed to provide Mount Crescent with documents regarding ACC standards and policies and procedures and guidelines, basically to ensure that Mount Crescent maintained a safe zipline operation. But that's an expansion of the duties that were required by Challenge Quest under the services agreement. And it ignores that Mount Crescent knew the importance of the safety protocols and in fact had the ACC standards and consulted with them.
Well, let me ask you just briefly on the safety manual aspect of things. Was there an obligation of Challenge Quest to provide a safety manual of some kind, A? And B, was there ever a model safety manual offered into evidence?
Your Honor, the answer to that's pretty simple, and I'll say this by prefacing it with saying, going back to the fact that if we provided a safety manual, the braking system that we were providing a safety manual on was not the braking system that was in place at the time that the plaintiff was injured in this case. It was an entirely new braking system.
Well, but we don't know for sure what the safety manual would say, I guess. I mean, it might say, theoretically, the safety manual might say you have to have redundant braking system and you have to be prepared for human error. And maybe would give some advice. I mean, you get where I'm coming from.
I do, Your Honor, and I want to answer your question directly, but I want to preface it by saying we don't believe this is a material fact for all the reasons that I mentioned before. But the fact is that Challenge Quest provided a outline for an operations manual for Mount Crescent to create its own safety manual, which they in fact did. That's reflected in the record. But at the end of the day, this is about the human error that was involved and the fact that the plaintiff, that Mount Crescent's employee forgot to do something that he knew how to do, which is reset the brake. And I've gone over my time, and I'll yield the rest of it to counsel for Mount Crescent.
Thank you. Mr. Henderson?
May it please the court, my name is Tom Henderson, and I'm here with my co-counsel, Peter Chalik. We represent Mount Crescent. I have about 5 minutes, so if you have questions for me, I hope that you'll feel free to ask, but I will.
About this one,
Right.
why should we enforce waivers against claims of gross negligence in Iowa?
Well, that's an excellent question, Your Honor. The reason why we should allow waivers for gross negligence on purely recreational activities is that they are voluntary. And the great thing about the state of Iowa is that we have held high the freedom of individuals to contract and knowingly assume the risk for certain recreational activities. These activities are not mandatory, and these recreational activities are numerous across the state of Iowa, and people enjoy them. So why not give them a chance to do that? In this,
I mean, let me offer a different perspective. When those activities arguably don't have the same social benefits as other activities, say ziplining may be enjoyable, but it's not making the world a better place or whatever. And when people get hurt, everybody in Iowa ends up paying the cost of that. It's not just the person that's engaged in the activity, it's primarily that person, but medical costs end up being distributed socially. So why shouldn't the entity that's responsible for the injuries bear the bill?
well, there's a couple different reasons. First of all, again, back to the issue about assuming the risk. People should know that if you do an activity that's inherently dangerous, and these are, and most people don't get hurt. These are enjoyable activities. Things like kickboxing and car racing and football and baseball and wall climbing and skiing and motocross, bicycle riding, soccer, and even this type of activity where you're high and going fast present certain dangers. So what we're saying is know that these are dangerous activities. They're totally voluntary, recreational, and yet assume the risk. And if you're assuming the risk, why allow for gross negligence? Gross negligence will just be a situation where plaintiffs will use that to get into court as another excuse. Whether or not there's gross negligence or not doesn't make any difference. They can still
We
file
have
the action.
no difficulty enforcing gross negligence, and it's a high standard, for example, in the workers' comp area, correct?
That it is a very high standard, Your Honor, and it's one where there's been many gross negligence cases appear before this body. But it's not something that's always been easy to decide either. I don't think there's been a lot of cases in which this court has found that there was gross negligence. But nonetheless, those type of voluntary activities I described might fit the terms of gross negligence. You get into a kickboxing situation and you look at gross negligence, and the definition under Thompson is, to prevail, the plaintiff must prove knowledge of the peril to be apprehended, knowledge that the injury is probable as opposed to possible, result of danger, and 3, a conscious failure to avoid the peril. And a lot of these things... Go ahead.
Yeah, isn't that a pretty high standard? I understand the argument that, well, you could put a label in a pleading, add the term gross, just kind of throw it in just every pleading that's out there on negligence, and it overwhelm the court system. That's the argument, I gather. But the elements of gross negligence are really fairly high, as you just recited.
Right. I agree that they are fairly high, but I still go back to my original comment, which is, why have it at all then if it's a fairly high standard? This is still a recreational
Counsel?
activity. Yes.
Over here, sorry. Because that is a high standard, how does any and all negligence, the language that was used in this waiver, give notice that it's also waiving gross negligence as opposed to negligence claims?
Well, thank you for asking that question as well. That's an excellent question, because negligence and gross negligence are basically the same thing. Gross negligence has been defined by this court as just a higher element of negligence. If you look at the definition in Thompson, it states the term, quote, gross negligence, end quote, is said to be nebulous without a generally accepted meaning. It implies conduct which, while more culpable than ordinary inadvertence or inattention, differs from ordinary negligence only in degree, not kind. So it's not a different type of thing, it's just negligence. It's a different form of negligence. Now you might ask, do we have to put gross negligence or negligence per se in the release? I don't think so, because to most lay people, that doesn't make any difference. It's negligence. Any and all negligence has been included so that people know that. And I think most people who are lay people understand that. It's much easier to understand than what gross negligence is. Gross negligence is something that we as lawyers talk about all the time. It's a very complex situation. But we tell lay people when they sign the release that any and all negligence means that you can't bring a lawsuit for anything that's negligence, and if you want to participate in this particular activity, which is inherently dangerous. And we have lots of warnings in the release that it is a dangerous activity.
Counsel, in terms of kind of maximizing social utility, I understand these are inherently dangerous activities, but why wouldn't we want to have a rule that encourages providers or people who provide these kinds of dangerous recreational activities to at least engage in some sort of safety precautions that don't constitute or that preclude gross negligence, right? That allows people to enjoy these activities, assume the risk of harm that might occur from a lack of reasonable care, but protect them from really extreme and unnecessary risks. It doesn't seem to me to be an unreasonable ask.
No, it's not an unreasonable ask. And in the particular ride that we're talking about, it is something subject to inspection by the state of Iowa. So there are safety factors involved. In addition, I think that the operator definitely has an interest in making sure that people don't get hurt. And, there's literally tens of thousands of people that have been on this ride. To contrast to what the plaintiff said about this being a dangerous ride, it is not that dangerous. There's been very few injuries, but there's always that risk of harm that can occur in any particular ride. So this is subject to inspection. There were requirements and certifications that had to be passed before the facility was built. So I think those protections are already in place by the state of Iowa. In addition, with regard to the public policy argument in this particular case, there shouldn't be a public policy argument with regard to this particular issue, in light of the fact that, I see my time is up, I apologize.
You may wrap up.
A moment to conclude.
Yeah, me, over here, yep.
Thank you, Your Honor. We would just ask that the well-reasoned decision of the court in this case, at the district court level, be affirmed and that summary judgment be permitted in this matter. Thank you, Your Honor.
Mr. Lathrop.
Thank you, Justices, and I want to Sorry about that, Justice Apple. I want to start by apologizing to opposing counsel. I promised I would take this down after I was done with mine, so it wasn't a distraction, and my blood was going, so I apologize. To respond to some of the points that came up on opposing counsel's arguments, there was an assertion that, well, this is the crossroads, as our decisions have said, this is the crossroads between tort and contract, and the court has that difficult job of balancing the two. We cite in our brief, and I'll go back to the restatement second of contracts, which section 195, which says a term exempting a party from tort liability for harm caused intentionally or recklessly is unenforceable, and that's what we're talking about here. There was also an argument about thrills are being sought and risky behavior is undertaken by people who aren't risk takers for the thrill of the ride, and there's risks inherent in that. I use as an example, if I went parachuting. If I were to jump out of a plane in a parachuting operation, the difference between negligence is, the jump master pushes me or somehow bumps me and jostles me, and I'm injured in the exit of the plane. Gross negligence in a parachuting case would be the chute packer not being trained, not knowing what he's doing, having no supervision at all, and sticking.
But counsel, as I try to think through what someone signing one of these release forms might be thinking in terms of the dangers that they're signing on to, they would be signing on to a danger that perhaps they're not going to be buckled in appropriately and they're going to fall off, or that something's going to happen with the zip line that's going to cause the whole thing to fall, or that they're not going to stop at the end and hit something. I mean, isn't this the sort of problem that one might have in mind when engaging in this?
As I was listening to opposing counsel's argument, I was thinking about that. And in my mind, if I were to decide I'm going to go on a zip line in Nicaragua and go through a canopy zip line, I have a different apprehension of the risks than I do here in the United States, and especially in Iowa. And I don't think people contemplate that I'm going to run into a phone pole at 35 miles an hour at the end of this thing because of chance. I think that people like thrills because it feels like there's risk, but we know in the back of our mind that there is none. And when people sign up for a zip line ride to go 40 miles an hour, the length of the Empire State Building at Mount Crescent, they're doing so because it feels dangerous. Just like Mr. Lukken, it felt dangerous, but we know, and we, in the back of our mind, a danger in this is not that people are going to be asleep at the switch and they aren't going to have the necessary safety measures or the safety standards met. So I hope I've answered that question. Yes, okay.
I'd like to follow up on the manual training issue that I raised with counsel, your opposing counsel. Tell us your view on what created the duty to create A as manual and B provide training, and B whether there's any causation.
Thank you, Justice Apple. Here's the short answer with an analogy, and that is, appellants would argue that manufacturers have figured out how to promote safe use of their product long after the product leaves their hands, long after the product is resold, and long after modifications are made to that device. The manufacturer's solution to that is a well-written owner's manual. There are warnings all over manuals for our cars, for blenders, and for any product we buy in a hardware store, and those warnings tell us things like, warning, if there is no secondary brake on this zip line, people will be injured or killed. That is simple. And the second thing about the training manual is, warning, if you are not annually retrained by a certified ACCT qualified professional, you will not possess the necessary understanding of this equipment to operate it safely. And if we had an owner's manual that provided those warnings to Mount Crescent, and didn't rely on Mount Crescent to go out in its unsophisticated own way and draft its own manual, this could have been avoided. But we don't have that manual. CQ built it, gave it a rubber stamp, and handed the keys over to Mount Crescent. I hope that answers the question. So we come back to where we began here. The issue before the court is whether we're going to enforce waivers in cases of gross negligence and willful inaction, and whether summary judgment was appropriate in this case when there's evidence of gross negligence and willful inaction. And I think the answer to both those questions for this court is no. Thank you.
Thank you. The case of Lukken versus Challenge Quest is hereby submitted. We will take a brief pause for a changing of the guard and allow the next attorneys, once the tables are empty and clean, to take their places.